Hello, everyone. Today's case is Stump v. Sparkman. This is regarding judicial immunity. A mother filed a petition in affidavit form in an Indiana circuit court, a court of general jurisdiction under an Indiana statute, for authority to have her somewhat autistic 15-year-old daughter, a respondent here, sterilized, and petitioner circuit judge approved the petition the same day in an ex parte proceeding without a hearing and without notice to the daughter or appointment of a guardian ad litem. The operation was performed shortly thereafter, the daughter having been told that she was to have her appendix removed. About 2 years later, she was married, and her inability to become pregnant led her to discover that she had been sterilized. As a result, she and her husband, also a respondent here, filed suit in federal district court pursuant to 42 U.S.C. subsection 1983 against her mother, the mother's attorney, the circuit judge, the doctors who performed or assisted in the sterilization, and the hospital where it was performed, seeking damages for the alleged violation of her constitutional rights, holding that the constitutional claims required a showing of state action and that the only state action alleged was the circuit court's approval of the sterilization petition. The district court held that no federal action would lie against any of the defendants because the circuit judge, the only state agent, was absolutely immune from suit under the doctrine of judicial immunity. The Court of Appeals reversed, holding that the crucial issue was whether the circuit judge acted within his jurisdiction, that he had not, that accordingly he was not immune from damages liability, and that in any event he had forfeited his immunity because of his failure to comply with elementary principles of procedural due process. Held. The Indiana law vested in the circuit judge the power to entertain and act upon the petition for sterilization, and he is, therefore, immune from damages liability, even if his approval of the petition was in error. A judge will not be deprived of immunity because the action he took was in error, was done maliciously, or was in excess of his authority, but rather he will be subject to liability only when he has acted in the clear absence of all jurisdiction. Here, there was not clear absence of all jurisdiction in the circuit court to consider the sterilization petition. That court had jurisdiction under the Indiana statute granting it broad general jurisdiction, it appearing that neither by statute nor by case law had such jurisdiction been circumscribed to foreclose consideration of the petition. Because the circuit court is a court of general jurisdiction, neither the procedural errors the circuit judge may have committed nor the lack of a specific statute authorizing his approval of the petition in question rendered him liable in damages for the consequences of his actions. The factors determining whether an act by a judge is judicial relate to the nature of the act itself, whether it is a function normally performed by a judge, and the expectation of the parties, whether they dealt with the judge in his judicial capacity. And here, both of these elements indicate that the circuit judge's approval of the sterilization petition was a judicial act, even though he may have proceeded with informality. Disagreement with the action taken by a judge does not justify depriving him of his immunity, and thus the fact that in this case tragic consequences ensued from the judge's action does not deprive him of his immunity. Moreover, the fact that the issue before the judge is a controversial one, as here, is all the more reason that he should be able to act without fear of suit. Reversed and remanded. Justice White delivered the opinion of the court in which Chief Justice Berger, Blackmun, Rehnquist, and Stevens joined. Stewart filed a dissenting opinion in which Marshall and Powell joined. Powell filed a dissenting opinion, and Brennan took no part in the consideration or decision of the case. Mr. Justice White delivered the opinion of the court. This case requires us to consider the scope of a judge's immunity from damages liability when sued under 42 U.S.C. subsection 1983. The relevant facts underlying respondent's suit are not in dispute. On July 9, 1971, Ora Spittler McFarland, the mother of respondent Linda K. Spittler Sparkman, presented to Judge Harold D. Stump of the Circuit Court of DeKalb County, Indiana, a document captioned Petition to have tubal ligation performed on minor and indemnity agreement. The document had been drafted by her attorney, a petitioner here. In this petition, Mrs. McFarland stated under oath that her daughter was 15 years of age and was somewhat autistic. although she attended public school and had been promoted each year with her class. The petition further stated that Linda had been associating with older youth or younger men and had stayed out overnight with them on several occasions. As a result of this behavior and Linda's mental capabilities, it was stated that it would be in the daughter's best interest if she underwent a tubal ligation in order to prevent unfortunate circumstances. In the same document, Mrs. McFarland also undertook to indemnify and hold harmless Dr. John Hines, who was to perform the operation, and the DeKalb Memorial Hospital, where the operation was to take place, against all causes of action that might arise as a result of the performance of the tubal ligation. The petition was approved by Judge Stump on the same day. He affixed his signature as Judge, DeKalb Circuit Court, to the statement that he did hereby approve the above petition by affidavit form on behalf of Ora Spittler McFarland to have tubal ligation performed upon her minor daughter, Linda Spittler, subject to said Ora Spittler McFarland covenanting and agreeing to indemnify and keep indemnified Dr. John Hines and the DeKalb Memorial Hospital from any matters or causes of action arising therefrom. On July 15, 1971, Linda Spittler entered the DeKalb Memorial Hospital, having been told that she was to have her appendix removed. The following day, a tubal ligation was performed upon her. She was released several days later, unaware of the true nature of her surgery. Approximately 2 years after the operation, Linda Spittler was married to respondent Leo Sparkman. Her inability to become pregnant led her to discover that she had been sterilized during the 1971 operation. As a result of this revelation, the Sparkmans filed suit in the United States District Court of the Northern District of Indiana against Mrs. McFarland, her attorney, Judge Stump, the doctors who had performed and assisted in the tubal ligation, and the DeKalb Memorial Hospital. Respondents sought damages for the alleged violations of Linda Sparkman's constitutional rights. Also asserted were pendent state claims for assault and battery, medical malpractice, and loss of potential fatherhood. Ruling upon the defendant's various motions to dismiss the complaint, the district court concluded that each of the constitutional claims asserted by respondents required a showing of state action, and that the only state action alleged in the complaint was the approval by Judge Stump, acting as circuit court judge, of the petition presented to him by Mrs. McFarland. The Sparkmans sought to hold the private defendants liable on a theory that they had conspired with Judge Stump to bring about the allegedly unconstitutional acts. The district court, however, held that no federal action would lie against any of the defendants because Judge Stump, the only state agent, was absolutely immune from suit under the doctrine of judicial immunity. The court stated that whether or not Judge Stump's approval of the petition may in retrospect appear to have been premised on an erroneous view of the law, Judge Stump surely had jurisdiction to consider the petition and to act thereon. Accordingly, under Bradley v. Fisher, Judge Stump was entitled to judicial immunity. On appeal, the Court of Appeals for the Seventh Circuit reversed the judgment of the district court, holding that the crucial issue was whether Judge Stump acted within his jurisdiction, and concluded that he had not. He was accordingly not immune from damages liability under the controlling authorities. The Court of Appeals also held that the judge had forfeited his immunity because of his failure to comply with elementary principles of procedural due process. We granted certiorari to consider the correctness of this ruling. We reverse. The governing principle of law is well established and is not questioned by the parties. As early as 1872, the court recognized that it was a general principle of the highest importance to the proper administration of justice that a judicial officer, in exercising the authority vested in him, should be free to act upon his own convictions without apprehension of personal consequences to himself. For that reason, the court held that judges of courts of superior or general jurisdiction are not liable to civil actions for their judicial acts, even when such acts are in excess of their jurisdiction, and are alleged to have been done maliciously or corruptly. Later, we held that this doctrine of judicial immunity was applicable in suits under subsection 1 of the Civil Rights Act of 1871, 42 U.S.C. subsection 1983. For the legislative record gave no indication that Congress intended to abolish this long-established principle. The Court of Appeals correctly recognized that the necessary inquiry in determining whether a defendant judge is immune from suit is whether at the time he took the challenged action he had jurisdiction over the subject matter before him, because some of the most difficult and embarrassing questions which a judicial officer is called upon to consider and determine relate to his jurisdiction. The scope of the judge's jurisdiction must be construed broadly where the issue is the immunity of the judge. A judge will not be deprived of immunity because the action he took was in error, was done maliciously, or was in excess of his authority. Rather, he will be subject to liability only when he has acted in the clear absence of all jurisdiction. We cannot agree that there was a clear absence of all jurisdiction in the DeKalb County Circuit Court to consider the petition presented by Mrs. McFarland. As an Indiana Circuit Court judge, Judge Stump had original exclusive jurisdiction in all cases at law and in equity whatsoever. Jurisdiction over the settlement of estates and over guardianships, appellate jurisdiction as conferred by law, and jurisdiction over all other cases, matters, and proceedings where exclusive jurisdiction thereof is not conferred by law upon some other court, board, or officer. This is indeed a broad jurisdictional grant, yet the Court of Appeals concluded that Judge Stump did not have jurisdiction over the petition authorizing Linda Sparkman's sterilization. In doing so, the Court of Appeals noted that the Indiana statutes provided for the sterilization of institutionalized persons under certain circumstances, but otherwise contained no express authority for judicial approval of tubal ligations. It is true that the statutory grant of general jurisdiction to the Indiana Circuit Courts does not itemize types of cases those courts may hear, and hence does not expressly mention sterilization petitions presented by the parents of a minor. But in our view, it is more significant that there was no Indiana statute and no case law in 1971 prohibiting a circuit court, a court of general jurisdiction, from considering a petition of the type presented to Judge Stump. The statutory authority for the sterilization of institutionalized persons in the custody of the state does not warrant the inference that a court of general jurisdiction has no power to act on a petition for sterilization of a minor in the custody of her parents, particularly where the parents have authority under the Indiana statutes to consent to and contract for medical or hospital care or treatment of the minor, including surgery. The district court concluded that Judge Stump had jurisdiction under subsection 33-4-4-3 to entertain and act upon Mrs. McFarland's petition. We agree with the district court, it appearing that neither by statute nor by case law has the broad jurisdiction granted to the Circuit Court of Indiana been circumscribed to foreclose consideration of a petition for authorization of a minor's sterilization. The Court of Appeals also concluded that support for Judge Stump's actions could not be found in the common law of Indiana, relying in particular on the Indiana Court of Appeals intervening decision in AL v. GRH. In that case, the Indiana court held that a parent does not have a common law right to have a minor child sterilized, even though the parent might sincerely believe the child's adulthood would benefit therefrom. The opinion, however, speaks only of the rights of the parents to consent to the sterilization of their child and does not question the jurisdiction of a circuit judge who is presented with such a petition from a parent. Although under that case a circuit judge would err as a matter of law if he were to approve a parent's petition seeking the sterilization of a child, the opinion in AL v. GRH does not indicate that a circuit judge is without jurisdiction to entertain the petition. Indeed, the clear implication of the opinion is that when presented with such a petition, the circuit judge should deny it on its merits rather than dismiss it for lack of jurisdiction. Perhaps realizing the broad scope of Judge Stump's jurisdiction, the Court of Appeals stated that, even if the action taken by him was not foreclosed under the Indiana statutory scheme, it would still be an illegitimate exercise of his common law power because of his failure to comply with elementary principles of procedural due process. This misconceives the doctrine of judicial immunity. A judge is absolutely immune from liability for his judicial acts, even if his exercise of authority is flawed by the commission of grave procedural errors. The court made this point clear in Bradley, where it stated, This erroneous manner in which the court's jurisdiction was exercised, however it may have affected the validity of the act, did not make the act any less a judicial act, nor did it render the defendant liable to answer in damages for it at the suit of the plaintiff, as though the court had proceeded without having any jurisdiction whatsoever. We conclude that the Court of Appeals, employing an unduly restrictive view of the scope of Judge Stump's jurisdiction, erred in holding that he was not entitled to judicial immunity. Because the court over which Judge Stump presides is one of general jurisdiction, neither the procedural errors he may have committed nor the lack of a specific statute authorizing his approval of the petition in question rendered him liable in damages for the consequences of his actions. The respondents argue that even if Judge Stump had jurisdiction to consider the petition presented to him by Mrs. McFarland, he is still not entitled to judicial immunity because his approval from the petition did not constitute a judicial act. It is only for acts performed in his judicial capacity that a judge is absolutely immune, they say. We do not disagree with this statement of the law, but we cannot characterize the approval of the petition as a non-judicial act. Respondents themselves stated in their pleadings before the district court that Judge Stump was clothed with the authority of the state at the time that he approved the petition, and that he was acting as a county circuit court judge. They nevertheless now argue that Judge Stump's approval of the petition was not a judicial act because the petition was not given a docket number, was not placed on file with the clerk's office, and was approved in an ex parte proceeding without notice to the minor, without a hearing, and without the appointment of a guardian ad litem. This court has not had occasion to consider, for purposes of the judicial immunity doctrine, the necessary attributes of a judicial act. But it has previously rejected the argument, somewhat similar to the one raised here, that the lack of formality involved in the Illinois Supreme Court's consideration of a petitioner's application for admission to the state bar prevented it from being a judicial proceeding and from presenting a case or controversy that could be reviewed by this court. Of particular significance to the present case, the court in Summers noted the following: the record does not show that any process issued or that any appearance was made, while no entry was placed by the clerk in the file, on a docket, or in a judgment roll. The court took cognizance of the petition and passed an order which is validated by the signature of the presiding officer. Because the Illinois court took cognizance of the petition for admission and acted upon it, the court held that a case or controversy was presented. Similarly, the Court of Appeals for the Fifth Circuit has held that a state district judge was entitled to judicial immunity, even though at the time of the altercation giving rise to the suit, Judge Brown was not in his judge's robes, he was not in the courtroom itself, and he may well have violated state and or federal procedural requirements regarding contempt citations. Among the factors relied upon by the Court of Appeals in deciding that the judge was acting within his judicial capacity was the fact that the confrontation arose directly and immediately out of a visit to the judge in his official capacity. The relevant cases demonstrate that the factors determining whether an act by a judge is a judicial one relate to the nature of the act itself, i.e., whether it is a function normally performed by a judge, and to the expectations of the parties, i.e., whether they dealt with the judge in his judicial capacity. Here, both factors indicate that Judge Stump's approval of the sterilization petition was a judicial act. State judges with general jurisdiction, not infrequently, are called upon in their official capacity to approve petitions relating to the affairs of minors, as, for example, a petition to settle a minor's claim. Furthermore, as even respondents have admitted, at the time he approved the petition presented to him by Mrs. McFarland, Judge Stump was acting as a county circuit court judge. We may infer from the record that it was only because Judge Stump served in that position that Mrs. McFarland, on the advice of counsel, submitted the petition to him for his approval. Because Judge Stump performed the type of act normally performed only by judges, and because he did so in his capacity as a circuit court judge, we find no merit to respondents' argument that the informality with which he proceeded rendered his action non-judicial and deprived him of his absolute immunity. Both the Court of Appeals and the respondents seem to suggest that because of the tragic consequences of Judge Stump's actions, he should not be immune. For example, the Court of Appeals noted that there are actions of purported judicial character that a judge, even when exercising general jurisdiction, is not empowered to take. and respondents argue that Judge Stump's action was so unfair and so totally devoid of judicial concern for the interests and well-being of the young girl involved as to disqualify it as a judicial act. Disagreement with the action taken by the judge, however, does not justify depriving that judge of his immunity. Despite the unfairness to litigants that sometimes results, the doctrine of judicial immunity is thought to be in the best interest of the proper administration of justice, for it allows a judicial officer, in exercising the authority vested in him, to be free to act upon his own convictions without apprehension of personal consequences to himself. The fact that the issue before the judge is a controversial one is all the more reason that he should be able to act without fear of suit, as the court pointed out in Bradley. Controversies involving not merely great pecuniary interests, but the liberty and character of the parties, and consequently exciting the deepest feelings, are being constantly determined in those courts, in which there is great conflict in the evidence and great doubt as to the law which should govern their decision. It is this class of cases which impose upon the judge the severest labor, and often create in his mind a painful sense of responsibility. The Indiana law vested in Judge Stump the power to entertain and act upon the petition for sterilization. He is, therefore, under the controlling cases, immune from damages liability, even if his approval of the petition was an error. Accordingly, the judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. Mr. Justice Brennan took no part in the consideration or decision of this case. Mr. Justice Stewart, with whom Mr. Justice Marshall and Mr. Justice Powell joined dissenting. It is established federal law that judges are of general jurisdiction are absolutely immune from monetary liability for their judicial acts, even when such acts are in excess of their jurisdiction and are alleged to have been done maliciously or corruptly. It is also established that this immunity is in no way diminished in a proceeding under 42 U.S.C. subsection 1983. But the scope of judicial immunity is limited to liability for judicial acts, and I think that what Judge Stump did on July 9th, 1971 was beyond the pale of anything that could sensibly be called a judicial act. Neither in Bradley v. Fisher nor in Pearson v. Ray was there any claim that the conduct in question was not a judicial act, and the court thus had no occasion in either case to discuss the meaning of that term. Yet the proposition that judicial immunity extends only to liability for judicial acts was emphasized no less than 7 times in Mr. Justice Field's opinion for the court in the Bradley case. And if the limitations inherent in that concept have any realistic meaning at all, then I cannot believe that the action of Judge Stump in approving Mrs. McFarland's petition is protected by judicial immunity. The court finds 2 reasons for holding that Judge Stump's approval of the sterilization petition was a judicial act. First, the court says it was a function normally performed by a judge. Second, the court says the act was performed in Judge Stump's judicial capacity. With all respect, I think that the first of these grounds is factually untrue and that the second was legally unsound. When the court says that what Judge Stump did was an act normally performed by a judge, it is not clear to me whether the court means that a judge normally is asked to approve a mother's decision to have her child given surgical treatment generally, or that a judge normally is asked to approve a mother's wish to have her daughter sterilized. But whichever way the court's statement is to be taken, it is factually inaccurate. In Indiana, as elsewhere in our country, a parent is authorized to arrange for and consent to medical and surgical treatment of his minor child. And when a parent decides to call a physician to care for his sick child or arranges to have a surgeon remove his child's tonsils, he does not, normally or otherwise, need to seek the approval of a judge. On the other hand, Indiana did in 1971 have statutory procedures for the sterilization of certain people who were institutionalized, but these statutes provided for administrative proceedings before a board established by the superintendent of each public hospital. Only if, after notice and an evidentiary hearing, an order of sterilization was entered in these proceedings, could there be review in a circuit court. In sum, what Judge Stump did on July 9th, 1971 was in no way an act normally performed by a judge. Indeed, there is no reason to believe that such an act has ever been performed by any other Indiana judge, either before or since. When the court says that Judge Stump was acting in his judicial capacity in approving Mrs. McFarland's petition, it is not clear to me whether the court means that Mrs. McFarland submitted the petition to him only because he was a judge, or that, in approving it, he said that he was acting as a judge. But however the court's test is to be understood, it is, I think, demonstrably unsound. It can safely be assumed that the court is correct in concluding that Mrs. McFarland came to Judge Stump with her petition because he was a county circuit court judge. But false allusions as to a judge's power can hardly convert a judge's response to those allusions into a judicial act. In short, a judge's approval of a mother's petition to lock her daughter in the attic would hardly be a judicial act simply because the mother had submitted her petition to the judge in his official capacity. If, on the other hand, the court's test depends upon the fact that Judge Stump said he was acting in his judicial capacity, it is equally invalid. It is true that Judge Stump affixed his signature to the approval of the petition as Judge DeKalb Circuit Court. But the conduct of the judge surely does not become a judicial act merely on its own say-so. A judge is not free, like a loose cannon, to inflict indiscriminate damage whenever he announces that he is acting in his judicial capacity. If the standard adopted by the court is invalid, then what is the proper measure of a judicial act? Contrary to implications in the court's opinion, my conclusion is that what Judge Stump did was not a judicial act, is not based upon the fact that he acted with informality or that he may not have been in his judge's robes or in the courtroom itself, and I do not reach this conclusion simply because the petition was not given a docket number, was not placed on file with the clerk's office, and was approved in an ex parte proceeding without notice to the minor, without a hearing, and without the appointment of a guardian ad litem. It seems to me, rather, that the concept of what is a judicial act must take its content from the consideration of the factors that support immunity from liability for the performance of such an act. Those factors were accurately summarized by the court in Pearson v. Ray. It is for the benefit of the public, whose interest it is that the judges should be at liberty to exercise their functions with independence and without fear of consequences. It is a judge's duty to decide all cases within his jurisdiction that are brought before him, including controversial cases that arouse the most intense feelings in the litigants. His errors may be corrected on appeal, but he should not have to fear that unsatisfied litigants may hound him with litigation charging malice or corruption. Imposing such a burden on judges would contribute not to principled and fearless decision-making, but to intimidation. Not one of the considerations thus summarized in the Pearson opinion was presented here. There was no case, controversial or otherwise. There were no litigants. There was and could be no appeal, and there was not even the pretext of principled decision-making. The total absence of any of these normal attributes of a judicial proceeding convinces me that the conduct complained of in this case was not a judicial act. The petitioner's brief speaks of an aura of deism which surrounds the bench, essential to the maintenance of respect for the judicial institution. Though the rhetoric may be overblown, I do not quarrel with it. But if aura there be, it is hardly protected by exonerating from liability such lawless conduct as took place here. And if intimidation would serve to deter its recurrence, that would surely be in the public interest. Mr. Justice Powell dissenting. While I join the opinion of Mr. Justice Stewart, I wish to emphasize what I take to be the central feature of this case. Judge Stump's preclusion of any possibility for the vindication of respondents' rights elsewhere in the judicial system. Bradley v. Fisher, which established the absolute judicial immunity at issue in this case, recognized that the immunity was designed to further the public interest in an independent judiciary, sometimes at the expense of legitimate individual grievances. The Bradley court accepted those costs to aggrieved individuals because the judicial system itself provided other means for protecting individual rights. Against the consequences of judges' erroneous or irregular action from whatever motives proceeding, the law has provided for private parties numerous remedies, and to those remedies they must, in such cases, resort. Underlying the Bradley immunity, then, is the notion that private rights can be sacrificed in some degree to the achievement of the greater public good deriving from a completely independent judiciary, because there exist alternative forms and methods for vindicating those rights. But where a judicial officer acts in a manner that precludes all resort to appellate or other judicial remedies that otherwise would be available, the underlying assumption of the Bradley Doctrine is inoperative. In this case, as Mr. Justice Stewart points out, Judge Stump's unjudicial conduct ensured that there was and could be no appeal. The complete absence of normal judicial process foreclosed resort to any of the numerous remedies that the law has provided for private parties. In sum, I agree with Mr. Justice Stewart that petitioner judge's actions were not judicial and that he is entitled to no judicial immunity from suit under 42 U.S.C. subsection 1983. Well, that was a good read. As always, if there's any case you'd like me to read, just drop it in the comments and I'd be happy to take a look. Thank you.